Hey everybody, welcome back to SEC Roundup. I'm Nick Morgan. I'm the co-founder of ICANN, Investor Choice Advocates Network, and one of the co-hosts of today's episode of SEC Roundup. I'm joined by my co-host, Tom Zaccaro. Tom, how are you doing?
I'm doing well, Nick. How are you doing?
I'm doing well. Nice to see you. Obviously, you're a board member of ICANN and co-founder with me and at Houston Hennigan. And for purposes of this episode, I think it's particularly relevant that you're a former chief trial counsel at the SEC, and so you're going to comment on some things where I think that's particularly relevant. We are joined by another former SEC enforcement attorney, Kari Axel. Kari, thank you for joining.
Hi, Nick. Thanks for having me.
Kari, of course, is a partner at the Waymaker firm, an advisory board member at ICANN, and in addition to being a former SEC enforcement attorney, also a former assistant United States attorney, and has some particularly relevant things for today's topic, which is the probable revisiting of disgorgement in SEC enforcement matters with a case that is seeking the Supreme Court's review. We can all butcher the party's name, but his name is Mr. Surepetch. That's what I'm going with. I apologize to Mr. Surepetch if I got that wrong. But earlier this year, Mr. Surepetch received an unfavorable decision from the Ninth Circuit in his SEC case, in which the SEC obtained disgorgement. He sought review from the Supreme Court. And just today, the SEC filed its response to his petition for review. And I think a little bit of a surprise there, because most often when SEC defendants ask the Supreme Court to review a decision, I think in most instances, the SEC says, no, it's okay, Supreme Court, you don't need to take a look at this case. We're fine with what happened down below. So it was a little bit of a surprise that the SEC, after reiterating that it thinks it has the better position, and the Ninth Circuit was correct in its view, the SEC said, yes, Supreme Court, there is what's called a split of authority among the circuit or appellate federal courts. And the SEC asked the Supreme Court to review it, which increases the probability that that will happen in the near term. We'll probably learn sometime in January whether or not the Supreme Court is in fact going to take up Mr. Surepetch's appeal. So that's a long wind up. To Tom, I would like you recently published an article in the Daily Journal that was quite timely, why the Supreme Court should revisit SEC disgorgement remedy. Looks like you may get your wish. Can you give us some of the background? Like why do we even care about this? What is disgorgement? What has the Supreme Court said previously, and what that makes Surepetch kind of an interesting case for the Supreme Court?
Thanks, Nick. So, the SEC has always considered um, disgorgement to be an equitable remedy, and there are some advantages to the SEC for it being treated as such. There's no statute of limitations for equitable remedies. Um, they do not aren't decided by a jury; they're decided by a judge. And if a defendant doesn't pay disgorgement, unlike a penalty, the defendant can actually be held in contempt, which can include a penalty up until including being put into prison until they comply with the order. So disgorgement is a very attractive and potent weapon for the SEC. In the late 2010s, the Supreme Court refashioned the disgorgement remedy to make it something other than an equitable remedy in certain circumstances. So the first decision was Kokesh, where the Supreme Court said that for the purposes of statute of limitations, uh, disgorgement should be treated as a penalty and subject to the 5-year statute of limitations for penalties. That got the defense bar excited, and there was a full attack on disgorgement that ultimately culminated in a decision called Liu versus the SEC. And in Liu, the court said, you know, disgorgement is an equitable remedy provided it satisfies certain conditions. And one of the conditions is that disgorgement is awarded to victims, was the language the Supreme Court used. So it was viewed then that for disgorgement to be an equitable remedy, there has to be a return to investors. And the court went on to say essentially that in order to be equitable, there has to be money recovered for the benefit of investors. Justice Thomas quite precociously said, we're not giving any guidance to the lower courts in our decision on how to implement this rule. And he turned out to be quite correct. The lower courts struggled with determining disgorgement, particularly in cases where there were no victims or where it was determined that the victims didn't lose any money. So now several circuits have weighed in, and there's a split in the circuits. The Second Circuit has ruled that if absent financial monetary harm to victims, disgorgement cannot be awarded in an SEC case. So the Second Circuit ruled there has to be some pecuniary loss to the victims. The First Circuit disagreed and said, no, you can award disgorgement even in the absence of harm to investors. And most recently, in Mr. Surepetch's case, the Ninth Circuit agreed with the First Circuit's position. So you have a clear split in the circuits that activates what Justice Thomas said 5 years ago, that there's no guidance to the lower courts. And the Surepetch cert petition is a great opportunity for the Supreme Court to come out and further clarify what it intended to say in the Liu case.
And the reason it's a great case for the SEC to ask for review, I think, from the SEC's perspective, is that the allegations against Mr. Surepetch were that he committed fraud in connection with a market manipulation scheme, and although the SEC didn't prove that there was any harm to investors in its case, I think the SEC views those facts to be favorable to it when it goes to ask the Supreme Court to review its decision. I will put in a little plug for ICANN's pending case in the Ninth Circuit, in which we have a very similar situation with different facts, and our clients in the PacWest case are not alleged to have committed fraud. And the SEC similarly did not prove that anyone suffered pecuniary harm as a result of their registration violations. But setting that aside, okay, so now Mr. Surepetch is seeking review in the Supreme Court, as you say, to do what Justice Thomas said maybe they should have done in the first place, which is give a little more guidance to the lower courts. Kari, you represent an entity called CalALTs, the California Alternative Investments Association. And on behalf of CalALTs, you submitted an amicus brief or a friend of the court brief encouraging the Supreme Court to review the Surepetch decision as well. Can you tell us a little bit about what your rationale was, what the reasoning was of why the Supreme Court should review this case, and maybe, in particular on behalf of your client?
Sure. And first, Nick, I'll say we also submitted one, as you know, in SEC versus Berry, also on behalf of CalALTs. So we've appeared in both of these on behalf of CalALTs. CalALTs is a nonprofit group. It's devoted to education and advocacy concerning alternative investments. You can think of alternative investments being novel, emerging types of asset classes. And of course, innovative, Americans are always coming up with, new ideas about things that people can potentially invest in. Digital assets obviously comes to mind, but there have been things over the course of the years. Syndicated loans was an area which was, innovative at a time, and it was unclear exactly whether it was a security or not. Of course, even in SEC Berry, we have these life settlements about which there were, questions about whether registration was required. So those types of things, CalALTs is interested in, championing American innovation in these types of novel emerging asset classes. So, how does this SEC disgorgement, these rulings concerning SEC disgorgement affect them? Well, very much as in the SEC versus Berry case, where there is doubt about whether certain registrations are required, whether SEC registration is required, you might have a very sophisticated company or asset managers who even have legal opinions, perhaps, that are going out there and offering investments. And then with, 2020 hindsight, years down the road, someone says, actually, registration was required for this. And, Mr. Barry, or whoever the particular defendant is, are on the hook for disgorgement. Well, so what does disgorgement mean? And as you said, SEC versus Barry is a great case in point, because in that case, all the investors were set to make money. No one lost money. So, what is the point of disgorgement? What are we asking somebody to disgorge for? The registered representatives or the individual salespeople to have to pay something on behalf of this. So these issues have arisen, and they are important to investment managers. And in Surepetch, our amicus brief, I think the petitioner's amicus brief really focused on what Tom set up as the circuit split, the difference between the Second Circuit's case of Govil, the First Circuit, and now the Ninth Circuit saying no pecuniary harm is required. And I think we wanted to support the petitioner, of course, and get a review of this, but maybe we took a little bit more of a macro lens. I mean, Tom also began by talking about Kokesh, and I think there's a debate here where you get into exactly what, as does Thomas, what is the meaning of is within the particular Liu decision? When Liu says disgorgement does not exceed a wrongdoer's net profits and must be awarded for victims. Well, the SEC comes back and says that's not what Liu really means. Like Liu, in fact, it doesn't mean victims. It means for the benefit of the investors. And we promise to try to get it back to investors. So, that counts. And I think when you look at the broader, that trio of Supreme Court cases, not just Liu, I think it is clear it's not consistent with the Supreme Court's intent at all. And Kokesh, as Tom said, had a statute of limitations issue. But the Supreme Court in that case was very not unhappy, lecturing district courts about really exceeding the bounds of disgorgement and disgorgement becoming more like a penalty. And it said that, the disgorgement was punitive when it, when it became not tethered to being awarded for victims. It was not an equitable remedy when that happened. The other thing that I liked about focusing on Kokesh was Kokesh says that, if the SEC is really just going out to remediate some public harm, that's really not what disgorgement is about. And so if you don't have to prove, pecuniary loss to victims, then isn't that what you're doing, remediating a public harm?
Right.
And I think there's even language in Jarkesi, which is also very near and dear to your heart, where, the remedy has to be designed to restore the status quo. Well, if the status quo is already restored because the investor didn't lose money or is getting their money back, then, there's nothing for the court to do by way of disgorgement. It's just not an appropriate remedy in that context. So those were the points that we made on behalf of CalALTs in our amicus brief. And, as you said, SEC versus Barry is a nice vehicle. Also, would love for the court to consider that one because of the facts there involving registration violations and not fraud. They're interesting cases, both Ninth Circuit and in Surepetch, the court says, there's no requirement of pecuniary harm. You don't have to have victims. And it's more about, taking away what the defendant earned. The other thing we pointed out was that really leaves open this causation question. Well, what does somebody have to prove? And those of us that have tried a lot of SEC cases know this is a real issue. I mean, many times, and this is the case in Surepetch, he was able to brief the issue of remedies, but he consented to the judgment. And so it's just a pretty limited record.
Yeah.
And then the court shifts the burden to the defendant. All the government has to do is come up with, a rebuttable presumption of what the losses are. And then the burden shifts to the defendant. Right. Well, now we've got a low causation requirement and the burden of proof effectively when it comes to disproving the disgorgement. And then you get Barry where they say, well, you actually we're just going to presume harm. You don't need pecuniary harm because we're going to presume it whenever the time value of money, whenever you have a lost opportunity cost, we're just going to presume harm. But essentially that comes to the same result, which is you don't have to prove, the SEC doesn't have to prove pecuniary harm. And it's tremendously unfair to defendants, particularly, as you said, ones who relied on legal advice, ones who, are taking an opportunity to to innovate in our markets. And it does, and it will chill innovation.
And I think you make that last point in your brief really well, the chilling innovation. And I think that comes up going back to the beginning of your comments here, because people are innovative and they come up with new types of investment vehicles, some of which may be securities, some of which may not. If you are facing the possibility of a huge monetary judgment, even if there is no investor harm, well, why would you want to put yourself at that kind of risk? Why not just go do something else? So,
And we saw that, those of us that do a lot of crypto cases. I mean, we saw that. We saw an, exit of capital from the U.S. markets
yeah.
because, there was a concern that applying the Howey test retrospectively was going to mean, incredible, judgments against, any asset managers that attempted to, wade into those waters. So, we don't want to go back to that.
Right. Right. Well, it looks like we'll hear from the Supreme Court. I just looked at the docket, and Mr. Surepetch has waived any delay in hearing back from the Supreme Court. So my understanding is we ought to have some word from the Supreme Court in January. So we'll check back in and see if this case gets reviewed, and maybe we'll be fortunate enough to have the Berry case join Surepetch at the Supreme Court. Thank you.
Wish you good luck.
Thank you. Thank you. And we appreciate your amicus brief in our en banc review petition. Kari, thanks so much for coming on. Tom, good to see you as always. Everyone else, you want more information about ICANN, go to icanlaw.org, and we will see you on the next SEC Roundup. Thank you.